Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Welcome back to the third season of the Jury Thinks What, a podcast for trial lawyers by trial lawyers. And I'm your host and interviewer, for lack of a better word, Saul Gruber from Gruber Trial Consulting down in Florida. Today is either going to be the first or second edition of the third season. And I'm kind of pumped because we've got now $100 million verdict we're going to discuss. Yeah, that's right. $100 million verdict. And it isn't, Microsoft versus Apple. It's the type of case that every one of us has seen, and probably everyone listening now has a similar type case in their office. But we're going to hear from some special lawyers. Andrew Garza from the Connecticut trial firm. He and Ryan McKean started that firm, and you probably know his partner as one of the authors of Tiger Tactics. But Andrew is awesome. When you hear him talk to you about his thought process, why he did certain things in this premises products case, and his relentless attitude, that no matter what was told to him, he just smiled and went forward. It's really a master lesson in how to handle cases that can become complex, and how not just to take the first answer as gospel. It's really interesting to hear his thought process and how he goes through things. So I think you're really going to like it. So let's do it. Here is Andrew Garza from the Connecticut trial firm. We're going to be talking about focus groups as well as his huge $100 million verdict. So we are here, and this is actually the beginning. It's either episode 1 or 2 of our third season. Again, this is Saul Gruber, but I'm pretty excited about this because I remember when this verdict came out. We have Andrew Garza from the Connecticut trial firm. Andrew, how are you today?
Good. How are you? Good afternoon.
I'm doing pretty well. I first heard about your verdict when your partner, Ryan McKean, was talking about it, and I said, whoa. I mean, and for people who don't know, $100 million verdict is kind of impressive. I think you know that, though, right?
Well, thank you. Thank you.
I knew when this verdict came in, what did it come down, about 4 months ago?
Yeah, and about early October 5th.
I had you guys penciled in right away because I know everybody's going to want to hear not only about the case, but how you got to $100 million verdict. It's just fascinating stuff. A lot of people probably know your partner, Ryan, because he's one of the authors of Tiger Tactics, right?
Yep.
Yeah, and that's that book that every law firm has. Half the time they don't even realize they have it, but they have it and they follow it. Where Ryan wrote, I think, one of the chapters or 2 of the chapters in the book. So that's pretty impressive. So now you're at the Connecticut trial firm. You're banging out 7-8-figure verdicts, and Ryan is teaching everybody in the country how to manage a law firm.
We're doing what we can. Yeah. Ryan and I, when we co-founded the firm back in 2016, I mean, we never could have really imagined it'd be as big as it is. We just wanted to, build a nice, sustainable business with good people and do good work. And we're very grateful.
How many lawyers do you have there now?
We've got 7 lawyers now, up to about 28 people.
Wow.
Pre-lit, lit, and growing. So
that's awesome.
Yeah, if you're looking for work, we're looking for good people.
That's great. So you heard it here, guys. If you want to try to learn from people who get big verdicts, give Andrew a call. Connecticut, what's the litigation feel like in Connecticut right now? Do you have caps?
We don't have caps. Well, short of dram cases, dram shot cases, we've got a cap at 250. But other than that, no med mal, no charitable, no non-economic damage caps. And Connecticut's it's a strange animal. I mean, I think a lot of people when they think about it, they think like West Wing characters or that, but in reality, I mean, politicians stop in one zip code here down on the Gold Coast, and that's not where I grew up.
Well, and plus, I mean, Connecticut is a suburb of New York, at least a good chunk of Connecticut. So it's that, I always say it's not quite up in Maine yet, or any of the real the Northeast. Whereas I practice in New Jersey, so.
But parts of it look like it. I mean, you got cars on cinder blocks in rural parts. I mean, it's varied. We're outside of Hartford, the capital city, by about 10 minutes, mostly because the parking's easier and we can get in and out to our home court. But it's an interesting place to litigate and to work, and it varies. I mean, not quite as big as Texas in terms of county variability in jurors, but you have your conservative venues, your moderate and preferable venues too.
So I'm going to ask you the question I ask everybody. When you're looking at a county that you're going to try a case in, and we have them, whether in New Jersey, we had our very liberal counties, and we had our incredibly conservative counties, more Northwest. What do you like more? The more urban liberal counties, or the more conservative, sometimes suburban counties?
I mean, so I'm sort of a student now, fortunately, a teacher at the Keenan Trial Institute, and they're kind of fond of saying, that the county shouldn't matter, doesn't matter if you pick the right case. And
sure,
I mean, I think it can. I think it makes things easier than others, and I think it depends on the case, right? I mean we've seen in focus groups even that conservative jurors can be some of your biggest advocates in a case that's about big rule violations, or in terms of damages, that's a different story. They can be, but it just depends.
We've always found we found the same thing, and using Don's vernacular, Bubba likes rules, and if you tell Bubba what's supposed to happen and it doesn't happen, they want to hold somebody responsible. And I think in some of we see, at least in the nursing home world, some of the biggest verdicts come from the most conservative venues, because it's old people not being taken care of when they could have and should have.
Right. So, right. And in this case too, I mean, we can get into details at some point. We ran something like 10 focus groups, one of which helped to develop juror profiles. And what we saw was pretty uniformly this case. It didn't matter, liberal, Democrat, somewhere in between, conservative. This was a case that really it was you didn't need to worry about politics. I mean, people felt pretty similarly about what had happened in this case, and the question was getting good damages jurors, I think.
So interesting. When you say you ran about 10 focus groups, would you mind giving us a little background on how you go about doing that?
Not at all. So pre-pandemic, we ran them all in person, and then there's sort of been a shift to online, and that's been necessitated by the pandemic, and so we will post in community Facebook groups, because Craigslist is fine, but you sort of get a lot of the same people. And sort of more problematically, we've seen a rise in people that are participating from outside the country. I mean, no disrespect to people who live in Africa, but it's kind of funny. We have a video because we record them all. We have one focus group, and we're supposedly all these folks are from a county where I can tell you population wise percentage, it's not a large African-American population. And we get on, and every single one of these folks is 30 to 40 African-American male, has a first name, last name. It's all the same. It's all the same Gmail account. It's all from Nigeria. And we were like, well, this isn't going to be real helpful in determining juror attitudes in the area where I'm trying this case.
No, absolutely not.
You ask them, well, where's your favorite place to eat? The video goes off. They come back on. It's Wendy's. And, so we that's a long way of saying we got more sophisticated in running some surveys online where we could log IPs. And then we've asked people to provide a phone number for validation. So we've been able to get people online with a little bit of pre-screening. And then we run them. They're told their video recorded. We get consents and releases signed. So we can use them commercially if we need to teach, or we can use them in mediation statements. But, and then we run, the focus groups are varied. So I'm a focus group instructor at the Keenan Trial Institute, which I'm a big proponent of the courses there. I just like the hands-on, like small class size, 8 people, get on your feet, get uncomfortable.
So Professor Hoey works with you?
I guess I work for him because he's the dean, but Dave Hoey's he's a great guy.
Yes, and that I did all nursing homework.
Yeah, so a little bit about David Hoey, or a little bit about his work.
I know Dave. I'll text him in a minute if you'd like. I know Dave incredibly well, and We will talk to him after we're done this podcast. And I know that Don is very big on focus groups, and I'm doing them all over the country for a lot of clients. I mean, I hear lawyers don't want to spend the money for focus groups. What do you say to those people who think focus groups are a waste?
I mean, first thing would be, I get it. And depending on the kinds of cases you're handling and the relative size, you got to make some judgment calls. So if you're handling a bunch of smaller soft tissue cases, and my firm handles everything, we got folks who handle soft tissue stuff up to the death and products cases, but maybe you focus group 5 cases over an hour each or 45 minutes each if they're smaller, right? And, or you have, if you've got your bigger cases like this one, you can justify the expense of 6 to 8 people and run 10 of them.
Right.
But you have to. I mean, lawyers, I know we're people and we like to think we're normal.
We're not people and we're not normal.
No, I mean, and you have to gut check. I mean, ego gets in the way. You get, you think all the issues. You think this witness is incredible, and you may be right. But, you got to focus group some of these things and understand. There hasn't been a focus group we've done where I haven't come away from it and thought they saw something I didn't. They thought something I thought was important wasn't. And I think it's a standard of care, to be quite honest. And you can find a way to do it, whether it's at a community center in person for cheap, or you do it online, or you split the cost with other lawyers even who bring their cases.
I mean, how do you feel about moderating your own focus groups, though, for your own case?
It's tricky. So it's particularly tricky because we record all of our own depositions. So if it's a deposition like this case, I took most of them myself. There are times where I would talk less, or if it was a deposition that I had taken, they couldn't quite figure out who was who. And
right.
You start neutrally. You say, look, we've been hired. This is a real case. We've been asked, by the lawyers to give them some feedback. It matters. We're here because there's a disagreement or there's things they want to know. And so you may try to structure it with trying to have like an associate or a colleague moderate portions after your voice. You try to be careful about influencing them.
Absolutely.
And having
I've always found the most difficult part in dealing with plaintiff lawyers, which is, what I am. It's you either are or you aren't, right? You can't do both. That's always been my experience.
I agree.
But, they always want to win the focus group no matter what. And I take the opposite approach, as I'm sure you do. I put the best defense case you could possibly put forward and find out what the focus group thinks of that.
Yeah.
And as I'm doing that from the other room or the back of the room, my phone is blowing up furiously from the lawyers saying, well, tell them this, tell them that. I'm like, relax.
Well, that's exactly it, right? Talk as a lawyer. And all you can do. I look back at the videos of the ones I moderate, and I'm constantly trying to go, okay, I shouldn't have said anything there. Oh, they asked for a piece of information. I gave it to them. I shouldn't have given it to them.
Right.
The best thing you can do is say the least amount as possible. Yeah. Well, why do you ask that? Would it matter? Would it matter? Okay, you say this. Well, what if I told you it was that? I don't know. Why? Right. Why do you want to know? Who else wants to know why?
I've been making lists lately. I've been saying, okay, well, is that important to you? They say, yeah, well, what else is important to you? Let's go through what that could mean. And we just kind of exhaust and get lists for the lawyers that maybe they can use in depositions. You could have done X, you could have done Y, you could have done Z, and because that's what the focus group told us. And it just depends on the goal, right? If your goal, like we ran several in this case, 3 or 4, like Groundhog Day, that were we wanted to roll the case out in a neutral way, and we had pieces of evidence in this case that we knew were like plutonium. So we said, okay, well, we want to understand how they vote. So something we did was we did something simple like develop a Google form, right? Right. And the Google form just says enter your name, assign percentages of liability to these 5 people. And so we'd say, okay, maybe the first thing we're going to do is talk to these people very generally about maybe using only defense evidence about what this case is about. Absolutely.
There's some apportionment claims, right? They want to, everybody agreed my client wasn't at fault, at least by trial. And it was a matter of who and to what extent. So, we'd roll it out neutrally and we'd say, okay, without talking about it, nobody talk. Go here, go to this link, vote. Then we'll talk. Because you don't want the crosstalk to affect if you want to get, you don't want jurors, like you don't want one participant persuading the others. So we would do that. And then we would add, okay, well, let's talk about this negligent furnishment piece of it. Oh, it doesn't matter. Okay, well, what if I told you there was a post-accident drug test that was positive? Oh, of course, all of a sudden it matters, right? Right. And so you sort of see, okay, what if I told you we think there was some evidence destruction going on? Okay, how does that change things? And it was helpful to see how they changed and what they changed and what, at least as best you can, what we thought the
So I'm curious. I'm curious when you're doing that. Do you worry that the and I know we're off on a tangent, but I think this is awesome stuff. Do you ever worry that when you start adding facts, it starts to piss the focus group off because they've already reached a conclusion in their head. Now you're saying something to them that may detract from that conclusion. Are you getting real feedback from them, or are you not?
I don't know. I mean, I think we tend to get real feedback because we tell them, look, we're on this journey with you. We've been hired. I can give you information as I'm allowed to in the way that I'm allowed to. And, what do you think about this? The next thing I want to tell you is this. I want to have you look at these two things. Like one portion, we'd ask them general facts, and then we'd say, okay, I'm going to play you 5 minutes of a defense expert. I'm going to play you 5 minutes of the plaintiff's expert. What do you think? What do you think of these people? Some of them are like, well, I didn't like the guy. He looks like a corporate man. I didn't believe him even before he started talking, or I didn't like this, or I like that. So we try to present things sort of objectively without
absolutely
putting our thumb on it and let them talk.
The other thing I've noticed, I'd love to hear what your thought process is, and then we're going to jump into the facts of the case. Maybe if you have some time, we'll talk about the next trial that you had. That was what, $2 million verdict. What was the next one?
2.3.
Yeah. So, but we may not have time for that today. We may have to do that a different day. When you're dealing with some of the putting the case together, you really have to have your case trial ready when you do the focus group, in a sense, or at least really ready up to the date. I can't tell you how many people hire me and then I get there and the facts aren't right. And everything that they've sent me, they're not ready for it. Tell me about that, how you get ready in order to be able to ask simple questions at a focus group.
Yes. I mean, there's an extraordinary amount of prep that goes into the focus groups and working the cases up this way, but it's important. I mean, you need to be able to go through, to put that clip together of your expert.
Right.
Maybe I'm going to go through his 3 days of depositions in this guy's case, 500-600 pages, figure out, are there any portions of this where he just says it, he says what the theme is, what his theory is in 2 minutes, just sort of distill it down for them and then figure out what else they want to know. So, I mean, you're right. You had to have a sense of what you needed to present to them we were constantly simplifying the case. I mean, this is a case where they wanted it to be big and muddy and complex and blame one another and bring in indemnification claims if they could have. And, we wanted 1 or 2 rules and very simple. So, learned, go ahead.
Yeah. I mean, no, not at all. I mean, I think we all, when you get to a certain age and you've lost enough cases, you learn that the more complicated is good for the defense. The simple, direct, only the stuff that really helps you is good for us.
Yep.
Yeah.
Yep.
I mean,
it's I think the hardest part of trial work is figuring out which bullets to fire and which ones you don't need to fire. Just because you have that 6th, 7th, 8th point that you think is a home run on cross of an expert. Have they lost the thread? I mean, have they stopped listening to you because it's some nuanced point, or the hit isn't as clean as you think it is, or that, it's just, you pick your spots, get in, get out, sit down. Maybe don't cross an expert sometimes so they don't hurt you.
Yeah. Okay. Yeah. You ever hear the Irving Younger tapes?
I think so. He's the 5-7 rules of cross examination.
Yeah.
And
he would always, when I was in law school, we would listen to them all the time back in the 80s. And he would always say, just ask the 3 questions and sit down, but you won't. Will you? You can't help yourself. And I still listen to them because I still chuckle because he's absolutely right.
Yeah.
And what I found, and I just went over this with clients in the Midwest, is if you've got 3 really good points, if you're going to hit 3 more points with that expert, you run the risk of losing credibility, and you run the risk of having them say, well, geez, you're just going to pick on everything, aren't you? Anybody could do that. And it's scary.
Yep.
So
yeah. I was going to say something. Yeah, something too. I mean, they're the finer points too that I'm the beneficiary of people much smarter than me who've given me their time and the benefit of their experience. But there's things like, relative intensity of cross, right? So if they've got 3 experts and I get up and I absolutely obliterate one of them, but then I don't really have much to do with the second or the third, and so I do nothing, or I just make the little points I can about bias or money. From focus groups, that they say, well, actually, we just assumed they were better experts, that
right.
Maybe you didn't, so you actually have to consider the effect of, do you kill the first guy? Because by comparison, if you don't kill the second and third, it affects your credibility and the weight they afford that expert, or there's constantly a sort of an analysis that I think needs to be done.
Brian Jasper is a trial lawyer, works for the Thomas Law Firm in Louisville. And Brian, I was just talking to Brian about this. He looks at cases as whether they have like bombs, whether he can drop hand grenades, and where he wants to drop them. That he doesn't want to drop too many in a trial, and he wants to maybe have 1, 2, or 3 and only drop them once.
Yeah.
What do you think about that type of analysis?
I think that makes sense. I mean, it's all about timing, right? I mean, picking your moment. I mean, if you're going to focus on something, I mean, we know primacy and recency matters. So if you've got a big hit, maybe you hit it early because you know that's gonna color the rest of their experts.
Exactly.
You probably would. It'd be your second best point for last, maybe. I mean, strategically, I think you have to look at some of those things and understand too. When the witnesses you call and the witnesses you cross, if they're buried in the middle, they're just not going to be memorable.
I'm going back probably 25 years. I was trying the case. I think I was second chairing it for somebody, and he says to me, actually, she said to me, "You've got to delay this witness for a half an hour with just a bunch of stupid cross. It's going to kill your credibility. I don't care." I said, "Well, why?" So because we want to end with the next witness. And then when it gets to a certain time, just stop. And then I can come in and we can hit it. And it was a Friday, and we can hit it with a huge witness that they're going to talk about
all weekend.
And I never even thought that was something, and she said to me, "You're going to fall on the sword. You're only doing one more witness. Nobody cares. I don't care if you just look stupid for a half an hour. You're keeping that person on for a half an hour." Do you think about things like that when you're
We do. Yeah. And it also, I think to your point in that situation, you also have to think about the greater good, right? Because I think the lawyer ego is like, no, I want to go in and run my game plan. It's not about you. It's never about you. I mean, it is to the extent that you need to be credible, but it's about what's best for your client.
Right.
And if it means falling on a sword and doing the right thing thematically, it's an obligation.
Right.
And and we do look at things that way. Which witness do we want to start with? I mean, within practical constraints, right? I mean, which witnesses are available, but I mean, you generally, we want to start with the defendant first. I want the focus on the defendant. I don't want to come in with the beggar's cup, and that's what the case is about. The hardest cases to try are admitted liability, cases where it's all about your client and they're under scrutiny,
I mean, I've always said, and when I haven't done it, it's worked horribly. And when I've done it, it's worked okay, is you plan the trial. It's kind of like a play.
Yep.
You have to plot with either it's a storyboard or just a different legal pad. Here's what we're going to do with this witness, and we're going to insert it on day 2. Here's what you really have to. I mean, how do you go about doing that at your office? So
it's taken us a while I don't know that we perfected it, but at least to get organized. And we use like the Google Suite. So we have a separate G calendar Google Calendar will put in place for that trial. And it's, what the witness's name is, who's taking them, and then we'll move people around. We have people that are on standby. Okay, well, if this witness gets done, we've got these 3 people under subpoena that day, but there's a calendar where everybody knows who's coming in what day and where they're going to be called and what's going to happen. So it helps with traffic control on the back end and make sure we've got witnesses, because I'm not going to make a jury wait if you can avoid it.
Of course.
And but that's what it is. I mean, motions in limine, jury instructions here, that's going to be this period of time. Court lunch is this hour. I mean, everything to the extent we can control it is blocked out. I've got a couple of videos, maybe I got an expert video in the can. Right. If I can't avoid it, I can plug that in here. That's my second best option in this situation. If I get done early, or the cross goes easier than I thought, or it goes long. So we have a calendar that everyone's got access to on the trial team, and when witnesses are going to be called, who's going to take them, and we're constantly trying to stay organized.
Absolutely. And the other thing that we that we always did was we prepared a trial brief, so to speak, that had everything in it for the judge. I'm not even talking about the exhibits. It had with nursing home, it had the regulations we were going to address. It had every issue we thought was going to be an issue with a memo of law. We had it date stamped. And all we ever wanted was the judge to say, well, let's open up Mr. Gruber's brief, because we all have it. I'm on page 87, and I'm like, yes. That's all I ever wanted was in front of the jury, the judge to say something like that. Yeah. How do you feel about that type of stuff?
I think it's a great idea. And to the extent we could in this case, it was an animal. I mean, it was,
right.
We ended up settling with a lot of the parties before opening statement, and the case got cleaner, but it was, 2-3 weeks of jury selection with 5-6 lawyers, and constant barrage and inbound emotions. And so, we try to get ahead of it, and during the trial itself, the defense firm that we had, we like to do our best to agree on the things we can agree on and disagree, and just get them cleaned up. Here's the disagreement, Your Honor. Let's have argument on it. But I mean, we couldn't get a returned email. I mean, look, can we agree you're not going to do this, or you're going to nothing? So I mean, every morning we were proactively filing briefs the night before. Here's what we think they're going to do today. Maybe I'm wrong, but it kind of seems like they have a trend for bending the rules. And then it was a way to smoke out a lot of the games they were going to play and get ahead of it, or at least flag it for a judge who would reserve ruling and then be like, oh, is this the nonsense that Attorney Garza was referring to? Is this what you're trying to do right now?
I love that. I mean, what I see now too is defense are trying their entire case in motions in limine. They are trying to piecemeal and take every expert opinion completely out of context so that things that should never be kicked out are kicked out. Do you see that same pattern going on all the time?
So I don't know about the whole case part, but I definitely see, I've seen liberties taken with legal research and writing in the last year that I don't think would pass in law school and a legal reason. Just, I mean, because you have a duty of candor to the tribunal, and I'm not saying it's strictly unethical in that sense, but you look at it and you're like, at least from a credibility perspective, I can blow you up by providing the other half of that quote.
Right.
Like, I mean, you're making my job easy. You take the expert out of context, but oh, what's this ellipsis in the brackets doing a lot of lifting here? It's just, that's what you see. And you're like, and ultimately what ends up happening, to your point about briefing important issues, is you develop credibility. I mean, that trial, that judge knew that I would make reasonable concessions, not on fundamentals. But if he'd be like, well, doesn't the Supreme Court of Connecticut say this? And what are you going to say? You're going to say no? You're going to say yes, but we disagree factually because here's why. But I mean, they knew that with the research I had done, he could, at some point, he could rely on it. He knew I wasn't misquoting authority. I was making, and that became a huge thing because we realized we were better on the evidence than defense counsel. So at some point we stopped doing those proactive motions, and we would just cut him off at the knees in the middle of an examination, and he'd fumble. And he'd look disorganized. And so tactically we started to realize, okay, well, let's play to our strengths and, do our preparation, but the judge is getting irritated with the morning briefings too. So let's just wait and pick our spots.
So let's double back. Tell me a little bit about the case. And then we can maybe get into what the things you were really worried about and you weren't worried about at all. So why don't you tell us a little bit about the facts of the case to the best you can? I understand it's on appeal now and there are issues swirling around, as there always are in a $100 million verdict.
Yeah. So, if the case happened the incident happened back in September of 2017. So my client and his wife, both born in Puerto Rico, came to Connecticut when they were both very young, born, raised here, graduated from high school here, made their lives, their families here, had kids here. And he worked in a commercial warehouse in Connecticut that was pretty much a distributor of lighting products for Philips Lighting, almost exclusively. And on this particular day, it was a Wednesday, he walks into work after lunch, and you imagine a large commercial warehouse, not unlike a Home Depot, but it's not open to the public. And he goes into an aisle to pick some product for a customer order. And he's in the equivalent of aisle 6. And there's a temp worker in aisle 7 using a reach truck. And the guy knocks an object down on the upper rack, and it falls over into my client's aisle, and it paralyzes him.
Oh, my Lord.
And to the importance of focus groups too, we ran about 2 or 3 just explaining as best we could the mechanism of what happened. And we had some focus groups an hour and a half in where folks were like, well, your client was next to that guy on the reach truck in the same aisle. And we were like, we need the animations. We need clear-cut mechanism of injury. We've got to be able to show these folks what happened. Because then a 10-second and then countless questions became a 1-minute animation, to show them what happened. So my guy's paralyzed, emergency responders on scene. In minutes, OSHA comes, they do an investigation and, an inspection of the warehouse. And fortunately, we're hired pretty early. We're hired within a couple of weeks of the incident, and we do everything we can to send out preservation letters to preserve what can be. And, from the very beginning, I think the obvious case was against the temp and the temp company that had sent him. If your state allows you to sue folks that are temps, right? He's not a co-employee. Here we have exclusivity, but you can bring it against not a co-employee. And there was no agreement saying that this guy was. So the obvious answer was the temp, wasn't paying attention. It gets knocked down on my guy. Maybe he shouldn't have been there that day. And we also knew he was sent for a post-accident drug test that we believed to be positive at that point.
He being whom?
The temp.
Got it.
Yep. Good point on the pronouns.
Yeah.
So yeah, so I mean, so the immediate case was, well, this temp had a pre-employment drug screen the Friday before, it was negative. This happens on a Tuesday, Wednesday, and he's sent right after, and it's positive for an extraordinary amount of cocaine metabolites in his system, and that becomes a tricky issue in the case because cocaine, unlike alcohol or other depressants, I mean, the acute phase has gone pretty quickly. So
Right.
we needed someone to look at this, to say.
Well, I mean, I wouldn't know that, but I'll trust.
Yeah,
trust
but I mean, we had an expert toxicologist who would say, look, either given the amount in his system afterward, which is a remnant of cocaine, he either was acutely intoxicated at the time, or he had done such an extraordinary amount of cocaine either the night before when he left work, and he was coming down off of an extraordinary amount of recent use, any of which would have affected his psychomotor function. So we thought, well, this case is pretty much, that's what it is. And then we, like every case that we take, that, you try to look at the root cause of why something happens. And what may seem like the temp, ultimately we worked our way back in an investigation that led us to China, where this product was manufactured by a Philips subsidiary. And we figured out that we believed that the product was not secured properly to the pallet that it was on at the time it was stored up on that shelf. And had it been, this couldn't have happened, regardless of the condition of the temp.
I was going to say, wouldn't that almost obviate anything that the temp did or didn't do?
In the lawyer mind, yeah. In the jury mind, yeah, no. But that's exactly the difference, right? That I just can't get over. It's going to be, this guy had an extraordinary amount of cocaine in the system. What that means is for us to debate. But the bottom line is,
look at you quoting another Northeasterner. Little Mark Mandel being thrown at us today.
Right. And but our expert said, look, the bottom line is no matter who touched this next, I mean, it was coming down. I mean, they had made choices at the Philips warehouse before it was shipped out to their client that sealed this guy's fate. And we looked at those things and we went back, and, I give credit to my client who knows more about lighting than a lot of folks. And he initially said, look, I think there was something about that product that was coming in differently than the others. And we looked at it. And we went out and we figured out, basically, look, this was coming in a giant cardboard cube from China, and not on pallets, because you save room on the shipping containers and things are more stable that way for transport. But when they get to Pennsylvania, to this warehouse of Philips's, they put them on pallets. And the quality of the pallets they were using weren't good. My expert, I think, at one point called them hobo pallets because they were pallets people would go out and collect and then resell them for some amount of money.
I mean, that's always an interesting thing. When any time you have a case that involves pallets, you almost have to address the construction or how good the pallet is, right?
Yeah,
because that's always an issue. How was it when it first came in compared to how it was when the incident took place?
Right. And one of the things to look at too, we knew from the OSHA photos that there were some missing deck boards from the top of the pallet. And did that happen in transit? Was there damage? Were they shipping them out on trash pallets? What was it? Or as my expert said, probably 80 times, lousy pallets at the trial. But, so we started to look at all the materials that were used, what the packaging configuration was. And, at that point, Philips, I think their position was, what do we have to worry about? The guy's on drugs.
Right.
And we've from the very beginning said, look, we think you played a role in this, and we're going to hold you accountable for the extent to which you did. And for your listeners, I mean, the $100 million verdict, Philips was the last man standing when the music stopped at trial. I mean, that was against them, with some amount of portion to the temp, who we'd settled out with by that point. But it turned from a case where they, I think, for a long time thought, this isn't about us. We don't have anything to worry about. It's not, we didn't, this happened because of that guy. And ultimately the jury disagreed. They said this 90% happened because of what Philips did. And, so something that happens is, Philips, they do an investigation on their end, and their stories from the very beginning were shifting. They said, look, we don't even think what's in the OSHA photograph is our product. That was story number one. And so we said, well, it's got Philips in big letters, but I guess, when you take a 30B6 of the North American director of logistics for Philips, and the guy tells you that's not theirs, you go, okay, maybe it's not theirs. And so we sued everybody who touched that product from the time it left their loading dock to the
Wow.
floor of the warehouse in Hartford. Because if you tell me it's not yours, or you tell me if it is yours, it was modified because it looks different, something had to have happened, right? Because our
Right.
people in Connecticut didn't modify it, and you say it's not how it left. So what happened in between Mountaintop, Pennsylvania, and Hartford, Connecticut? And the
Have
answer
you
is
noticed? Oh, go ahead. The answer is
nothing. It arrived as it was shipped. But
have you noticed? And lately, this was not in federal court, right?
No.
Have you noticed in state courts that people play fast and loose, and they probably do it in federal court as well, with truth in 30b6 depositions?
Yeah. I guess I have to be careful about what I comment on.
Well, forgetting about this case for a minute.
Sure.
Forgetting about this case for a minute, but you're probably doing some sort of corporate designee deposition in every case, other than a simple car accident case.
Sure.
I mean, it seems to me what I'm seeing is that they're intentionally not educating themselves, and they're intentionally not finding out the answers to the key questions so they could say whatever they want.
Yeah, we've seen it. I mean, and whether it's, there's like Occam's razor, but there's also Hamlin's razor, right? Which is never ascribed to malice, which is adequately explained by stupidity.
Right.
And so it's a question of, well, are they purposely under-preparing them because they don't want them to hurt them, or they don't care? I mean, some part of it's lazy. Like I see lazy prep, last minute. Oh, were you asked to look at anything? What did you investigate? Oh, nothing and nothing. Well,
and it's dangerous in federal court to do that, because I think the magistrates take that seriously in federal court.
They do.
Yeah,
they do. And if you get the right judge in state court, which we had, I mean, we had a judge who took that very seriously, who was a litigator, who understood the rules, which isn't always the case, unfortunately. They hold him accountable. Okay, this was your guy. This is binding on him. And we have weird procedural rules, maybe, where, I mean, that 30b6 depo, I can use it in full as a video. We video record, so that's going to come in full for really any purpose for which it's proper. So I'm going to play that video if you're going to mess around and tell me you're not prepared, and it's going to be hard for you to get away from it.
Yeah, absolutely. So you've got, it's what's on the pallet. Was there an allegation of anything wrong with the lift or scissor or whatever it was that was taking it from the pallet?
Yeah, everybody agreed. Nothing wrong with the reach truck itself. No issue. No product liability issue there. And so the questions were: was there some issue with the rack? Was the product packaged properly? Was it modified somehow? Would this have fallen if they had done it safely? So we retained an expert out of Lansing, Michigan, named Dr. Singh, and he's an umpire. He's a straight shooter, 50-50, both sides, and he's a scholar. And he's like, look, the bottom line is, if this wasn't secured to the shipping pallet in that moment before the incident, it should have been. That's the industry standard, and it would have made a difference. It wouldn't have come down.
But don't you have to prove not only was it, but why? Like, how did it come about that it wasn't attached the right way?
Yeah, so that's where the 30b6 fund comes, or in our state it's like 12.7F. But so the first opponent's the director of logistics, and interestingly, he says there's no industry standard of care or requirement that something be secured to a shipping pallet. That's what he says. That becomes problematic because later one of the number two and number ones all say, oh no, it's been a long-standing written policy of ours. It's our internal law and rule, and we followed it in this case. So, initially it was, this is not a requirement. It's not required. We don't do it. And then when we were able to prove that this is your product and it doesn't look like it was modified, they said, well, wait a minute, if it's our product and it wasn't modified, we did it the safe way. It went out the safe way. Right. So it became problematic for them for a lot of reasons, because we were able to go inspect that warehouse in Pennsylvania in January of 2021, and people weren't flying as much right around then. So my expert drove from Michigan, I drove from Connecticut, and there was agreement about what we could see and how long we could spend. Sure. And I said this to other folks too. I mean, we walk in and you just feel like something's not quite right about the warehouse, and every upper rack in this very busy warehouse was empty. And we thought, well, that's curious, because one of the common sense theories in this case was, why was it up so high in the warehouse in Connecticut? Why was that big thing up so high, that big thing up so high? It was in like every deposition. We knew it had some focus group common sense appeal, even though there's no requirement that something be down if it's a certain weight, as long as the rack supported and it's secured properly. But it was interesting. And so it becomes more interesting because we're there for probably about, maybe 10, 15 minutes. And then they look irritated. The 30b6 opponents there that day, the lawyers, a couple other people, and, oh, you've seen enough. You're done here. And we were like, well, no, we just drove from Connecticut. We need to see the wrap machines. We need to see some other pieces of this. And at that point, really, Phillips's position was that thing in the OSHA photograph isn't ours because of how it looks. And because how it looks is not how we send things out. And I said, well, tell me why. And they said, well, it had this green plastic banding on it, and we don't send anything out that has that. That's not been on this product. I said, okay. So understandably, we're there in January and we're looking for anything.
Right.
That color
Sure.
green, any under the up, down, sideways, and we don't see anything. And there's resistance to us going down to look at the wrap machines that supposedly would have packaged this product. And we didn't notice at the time, but we took a bunch of photographs and we got back to our office from Pennsylvania, and I look at them, and I printed it out like 8.5 by 11. I run into Ryan at Ryan's office. I'm like, you're not going to believe this. I'm like, here's the OSHA photo. He's like, yep, seen it. Here's the photo from last week. And there's a single green band, the exact same color as the one on the OSHA photo on that product, hanging out of a trash can in the area where they didn't want us to go.
Wow.
So I said, well, I wouldn't want to have to explain why that is and why that's the only one in the warehouse that day in an area you didn't want us to go. But we said, okay, well, if I'm them, they're going to say, well, we now in 2021, we have stuff with that product, and
Right.
we didn't in 2017. Not a good look because it just happens to be the same color in the same warehouse on the product that hurt my client, but we'll see. So they disclosed their expert a couple of months later, and with his disclosure comes their materials, and we find out that he did an inspection months after us when we couldn't go. And he was pretty careful, and careful is a judgment call about what his motivations were. That will be decided in another case, but we zoomed in on the digital photos once we got them, and in the very, very upper corners or cut out of some of the photos were entire racks of upper product with green bands. And we were able to figure out, and nothing obvious, just the
Sure.
farthest corner zoomed in, green bands. And we were able to figure out based on where those photos were that it was exactly the area that had been emptied above that trash can with the green band when we were there.
Wow. That's,
And
I
so
don't
we
want
said,
you to comment too much
Yeah.
on it, because I know there's some sort of spoliation type case going in federal court that
yeah, so
stemmed from this. So
yeah, and I'll talk about what I can, because there's some part of that was a piece of this case, and we said, okay, well, they're still going to say now we have it, we didn't then, and coincidentally, I guess we had it when their expert went 2 months after us, but not the day I was there. Nope, that expert said I interviewed everybody there, the number 2, the number 1. I walked through that warehouse myself, and there wasn't green banding on any product of any kind, and I was told that they have never received, shipped out, or package themselves any product with any green band of any kind. And we
Ever.
said, you sure? Yes, ever. Not now, not then, not ever, they were fond of saying. And so we said, great, thanks. So then actually David Hoey enters the story, because I had a call to him and I said, we kind of want to save this for trial. What should we do? Should we confront them on camera about what we have with these photos? And he's like, and there's a lot of debate that goes back and forth.
Sure.
And ultimately it was, you got them on video. How are they going to hide from it and just go at it? So the same day, back to back, because I wanted to choose who I confronted. We did the number 2 at that warehouse, and that person said, not now, not then, not ever. The number 1 person says, not now, not then, not ever. And I asked him literally 13 times. He probably thinks I have a brain injury.
right.
Like, I've answered that already. No, I understand. We had some confusion about the policies and procedures early in this case. So I just want to make sure we don't misunderstand each other about what exists and what doesn't.
Sure.
We give them an opportunity to fix it, change anything. Nope. And I'm the person, there's no one in the world who knows that warehouse better than me, he says. I said, like Truman says, the buck stops with you. He said, yep. Then I say, I'm almost done. You want to change anything? And then I pull him up and I say, can you tell the jury, because I'm preparing this like as if it's going to get played at trial.
Absolutely.
Can you tell the jury why there's a green band on the trash can on this day? And we just zoom in on it. That's about the loudest pause I think that man has ever experienced in his entire life. And he's no explanation. Well, sir, did you or anybody at your direction remove that green band or any green bands from products that day before we came? Any modifications to that were? No, but no explanation for why it's in the trash can that day. That is green, right? We agree that's green?
Right.
Yeah, it's green. I mean, and how about the other one? How about this other photo where it's on every upper rack? They got no explanation. And
I'd like to let me break that down with you a little, because that's a fascinating question that we're all going to have. You think you have the home run, the smoking gun. When do you drop it, or do you save it for trial?
Yeah, and I think a lot of that calculus was, look, most cases don't get tried. This case we always prepared it for trial, like our cases, but in terms of, I think you asked me early on, like what things worked in this case, what things played a role, and the short answer is a lot played a role that I didn't have control over. Like my client and his wife are two of the best plaintiffs we've ever represented and may ever represent in our careers. And I'm not easy on my clients. Like I will tell them they're not going to, look, here's what our focus group says. They don't like you. I mean, you got to be real with people so they understand the risk. And if you want me to try the case, I will try it and I will go to the mat, but you got to understand the risk. And these people, we knew they were and are the two best plaintiffs ever. We said, well, how are they going to try this case if we confront them on this? And so part of it was whether you think it's likely. You got a catastrophic injury,
right? You
got drugs involved. You got this involved. It's a profits over people narrative, to its core. And this is, so let's just do it. Let's do it on video because either I'm going to have it. It's not getting any better for them,
right?
Or the case is going to go away. How do you try a case against a paralyzed man who's a great plaintiff, and they know that when you maybe are caught with some evidence problems?
Did they ever explain it? At any point in time?
At some point later, they said, yeah, no, we now ship out product with the green band on it, but that they had some completely contrived, I'll let the evidence do the talking in the next case, explanation for, well, there was this division at a warehouse in Connecticut and that had closed down and the timing and the racks and the product were new. And maybe he was confused, but that is for sure now there's some green bands on this product, but still definitely not then.
Right. Yeah. It's that old coincidence. Oh, we just didn't realize it was just, yeah, I don't think a jury ever buys that, by the way.
Well, no, and then it actually got even more fun because we took a last-minute deposition of a witness they wanted to call about a week before trial. In the OSHA photo, there was this empty wooden pallet where this product had fallen off of because it wasn't secured. And right next to it, another product that had a single green band on it. And we had seen it before, but we didn't really know whose it was. And then we got some better quality photos, and we asked this guy who's supposedly in this new division that didn't exist back in 2017. And he goes, oh, that's the same thing from the division that didn't exist back then in the photo next to the wooden pallet. And we were able to zoom in and he was able to figure out, oh, no, that's ours. He said, that's ours from Phillips, the same configuration, that's fixtures.
Sure.
Oh, so this exact thing with the same color green band on it was actually next to that other object in 2017, but it didn't exist at your warehouse at that time. All right. So it sort of fell apart because it's easy to keep the truth straight. I tell my clients for depot prep, yeah, we got to work on some things, but this because you've lived it.
Right.
A lot harder to keep a story together.
Yeah. And I every time I see a verdict, listen, I mean, $100 million verdict, you're peaking very early in your career, Andrew, is all I'm saying. But even a $5 million verdict, a $20 million verdict, along with that comes either a defense lawyer who is just a jerk, or a plan from the defense team that just violates common sense and all decency, and the jury just gets angry. That's been my experience. I mean, the bigger verdicts I've had have been because somebody on the other side just miscalculated their story.
Yeah, so there's a really good article. You could probably find it. It's a DRI article, Defense Research Institute article about like novel approaches to litigating high exposure cases. And it's an older article at this point, but they did an analysis of sort of what leads to nuclear verdicts. And here are the criteria that they identified as sort of playing a role. And in our case, we knew we had 6, 7. I mean, you have a catastrophic injury,
right? You
got to, you have one of the things is the quality of the plaintiff's lawyer. I don't think we were on anybody's radar at that point. I wouldn't have blamed them. But we did the work. The other things were, kind of novel, unique, not novel, but little weird idiosyncratic things, like they're self-insured for the first $1 million. And maybe that affects, how the investigation's conducted in-house. Like I'm still convinced Phillips, because they were self-insured for the first $1 million and because the drug issue was live early, they were like, we're not worried about this.
Right.
This is not, we know what this case is about and we don't need to do anything, or they're trying to cut costs, or they're,
I've never understood, though, when the defense looks at that, there's got to be multiple counsel, house counsel, insurance counsel. and they see, yeah, don't look at it, but he is paralyzed. Maybe we should bring excess coverage in now and say to put the excess carrier on notice right away, participate a little bit, and because you need to be protected.
Yeah.
I just never understood why they don't do that. I don't care what the SIR is.
No, I mean, and the other factors, I mean, one of the other factors is bad stuff. I mean, you can debate whether it existed in this case, but I think the jury came to a conclusion about Phillips's credibility based on that object in the trash can.
Absolutely.
And, we were like, how do they not see this? How do they not understand, how bad this is for them? So, I mean, you have a big injury, and then you also have things like, machismo. And I'm not saying that I don't have an ego and I don't care about my clients or think I'm right sometimes, but you can't fall in love with your case. I mean, I can't afford to. I'm still plaintiff's lawyer. I mean, maybe you can on the defense side because someone else is picking up the tab. But I mean, I have 3 kids under 7. I'm trying to do right by my client who has medical needs the rest of his life. I mean, I lived in a constant state of anxiety about the boogeyman under the bed and in the closet. Well, where are they going next? How do we get ahead of it? How do we protect this family?
Well, I can tell you as a plaintiff lawyer for 33 years, I've lived 35 years, 36 when you count law school, in a state of constant anxiety and worried about where the boogeyman is coming from. That never changes. I just want to let you know that.
Yeah. Well, but that's the job, right? Like they tell you anybody that's not nervous about trial work is, doesn't have a pulse, or they, preparation can get rid of some of the nerves and you can run focus groups, but it's a heavy responsibility, and it's to do that and to take that risk. And, and my clients, they believed in us. We told them, look, you only get one case and we respect your decision and we want you to know what the risks are here. And they believed in our work. But, to your point about how this happens, I mean, I think it was on everybody else's radar. There were other entities involved, the temp company, the owner of the racking warehouse. All those folks came to the mediation in June with Phillips. All of them but Phillips took it seriously.
Right.
And Phillips, we had mediation conditions we set in order to agree to show up. They violate them, in my opinion. We disagree on that, I guess. It breaks down after a day. And, the highest offer they made was $1.5 million. I mean, and a guy who's 42 years old, nobody blames him.
What was your life care plan?
The life care plan was tactically fairly modest. I mean, it was maybe about $5 or $6 million, which I now look at other plans and I realize maybe that's low, I guess. For
a 42-year-old.
Yeah, I mean the wages. I mean, I think all in the economic ask was about $15 million, and we kind of knew because I think again credibility is everything, and if you come in and you got $100 million life care plan, I think maybe the jury punishes you. And I'm not saying that I don't criticize people who've done this work longer and probably do it better than I do, but we came in and we had the experts explain why their numbers are what they are and why it could be more. Okay, it's this, but if he gets hospitalized more than the X amount every blank 0.2 years, we know the complications he's going to have. We know what that could mean for him, the people. So like they had evidence there to go higher.
Your life care plan was $15 million. What was the defense life care plan?
Modest. The funny part was I think I tallied it up and maybe it was under $1 million. It was 700, but their guy wouldn't even do the math. He just came in and nitpicked like little line items, and then he wouldn't tally it up because I don't think he wanted to be accountable for that number.
Right.
And actually, one of my favorite. There's a lot of favorite moments in this trial, but my colleague Andrew Ranks was cross-examining their life care planner, and he came in and he wasn't a doctor, and you don't have to be, but we had the gold standard guy who could stand up. He was going to stand tall. And he's asking their expert, he's like, he doesn't need this. He doesn't need physical therapy. He doesn't need the home care. He doesn't need an FES bike. And the guy says, no. And he goes, what's an FES bike? And the guy said, I don't know. And he said, but he doesn't need it. He said, no. You don't know what it is, but he doesn't need it.
Yeah, it's little things like that are awesome.
The jury laughed at him, and I have never. Yeah. Because experts are so used to testifying and they're so used to being taken seriously, and they laughed at him, and like his mask slipped, and he was like, "Oh, they see me. Whoops." I've never seen someone exit a courtroom as fast as that guy did when the examination was done.
So let's go back in time. The case comes in. It's obvious to everybody at your office. It's a tragedy. But forget about liability. It's a tragedy, right? It's a catastrophic tragedy. And now you know that this family is relying on you and your staff, which is a heavy burden. Tell me a little bit about the investigation you started to do as much as you can to figure out which direction to go?
Yeah, so initially it actually came in as a comp case, which I do very little of now, but maybe I should rethink that if this is what turns into third-party cases. But I actually represented him on the comp case as well over the
Got
years.
it.
And I mean, they did everything. They shall remain nameless, but I've never had a comp case in Connecticut where I've gotten penalties awarded for delayed, weekly indemnity payments more times than in this case. I've maybe had it once before. I had it.
So they did the whole investigation.
They did some of it. I mean, I was able to get out who the temp was early, but then we ended up filing suit early because they wouldn't tell us what the coverages were. They wouldn't. It wasn't even a good faith disclosure early. So we actually filed very early. This happens in September. We filed, I want to say, in March of 2018, and then we immediately started to bang on depositions. And the very, very first one, the first two that were taken were of the people in Connecticut at that warehouse, my guy's supervisor and the receiving supervisor, and then the next one we took was we went down to New Jersey to take the 30B6 deposition of the person that Phillips had. And at that point we realized, okay, well, our guy says it wasn't attached. It had been coming in consistently unsecured to the wooden pallet. And their guy says it's not a rule. They don't have to do it. They never did. And maybe it's not even their product. And then over time, we sort of figure out, well, now they say it is their product and they did the right thing, even though initially they said they didn't even have to do it and it wasn't a rule. And then there were all kinds of little fun inconsistencies, like, what turned into no policy, it's not a rule, turned into we've always had a policy, it's written. Right. And in fact, it's been on all the stretch wrap machines since the dawn of existence of this warehouse. And I said, okay, well, I have your expert's photos from when he went, and I have mine from when I went, and it wasn't on the machines. Why is that? And then I asked their expert. I don't think they liked this, but I think he told the truth at that point. And he said, I said, well, when you were there on site, they told you they had a policy. He said, yep. Did they tell you, did you ask to see it? He said, yeah. And I said, well, did they show it to you? So they didn't show it to me. They couldn't find it. And then later,
the
of
old
course,
policy they can't find.
Yeah, well, and then of course I deposed the number two, and she's the keeper of the policies, and those policies exist on a computer 10 feet from where that guy asked her, and were readily accessible, and she had access to them, and so it just becomes maybe she just misunderstood what he was asking for. Maybe the policy never existed. I don't know, Jerry.
Yeah,
but
yeah. How many depositions did you end up taking in this case?
Somewhere between maybe 30 and 45 by the time trial was done. Everybody that was in Connecticut that was around, a lot of experts, a lot of folks at Phillips that were involved, my client, damages witnesses, but counter experts, redepositions of experts, multiple sessions. So, it was a labor of love to the extreme, but
I hear from a lot of lawyers, and I know you're involved in some of the organizations I am, and whether we're on a listserv or a Facebook group, and I see all the time, this is a horrible case and they won't make an offer and they won't give me the insurance. What do you think I should do? You ever see that?
Yeah, I do see them sometimes. Yeah. And
I know what your answer is going to be, but why don't you tell them your answer just so they hear it again?
Get it into suit. If they're gonna force a decision early, make a decision early. And first of all, there's also a difference between getting a case into suit and trying it with hundreds of $1,000s in expenses over 5-6 weeks. But if they're not going to give you what you need to make a fair assessment, because how do I even tell my client what's fair if I don't know what the coverages are, who's at play, and we wanted to make sure that there was no stone left unturned in this investigation.
So what you're telling us, the gem that you're telling us that I think we all know already is file suit, find out the answers. The questions. You told me the questions a half an hour ago.
Yeah.
Of what this case was about. You've got to find the answers, and invariably it may take 10 depositions to get to the answer. But you're not going to be able to get the real value or a real offer unless you do that.
Yeah, I think I don't want to assume, but I think I can about your audience that it's an audience of people who are willing to do the work, and you have to either do the work or associate with someone who can do it with you. But you're never. I'm told tales. I'm 35, but I'm told tales of the heydays of the 80s where insurance companies just gave you policy limits and 5 times meds, and that's not the world that I've grown up in. In the last 10 years, I've grown up in a world where you got to litigate most cases, at least put them into suit, bang on a depo here or two, and to get value and to try cases so you have credibility. And so
that's exactly right. I mean, that's the purpose of this entire podcast. Is if you haven't tried a case and you want top dollar, it's just not going to happen.
No.
So you've got to just try the case, and trying the case can be scary.
Yes.
There have been many, and you know this because your sphincter is incredibly tight when there's $3 million on the table and you're saying no. It is quite the scary day.
Yeah, I mean, and it's easier when not. I don't want to say it's easier, but I think it was maybe easier for. I grew up with no money. I grew up in public housing, so I've never that amount of money is illusory to me. It doesn't,
right?
And it's not illusory to my client, and you have an obligation to counsel them appropriately. But I mean, if I've never had that money, that doesn't. I mean, it's a number on a piece of paper, and
exactly.
It's the number that's below the number I think it should be for this case. And hopefully, I can always do that. But
well, I mean, you know this already, and I know Ryan knows this already. By you guys going to the courtroom time after time, getting 7, 8, 9 million, 9-figure verdicts on more than one occasion, you're doing all your clients a favor. They don't know it yet, but they're going to get top number just because they're going to you guys, which is awesome.
And it means a lot to us because there's some other projects that we're working on to really, I think, try to improve the quality of the plaintiff's bar in Connecticut. And I as a young lawyer, I always got frustrated at the lawyers that would sit around at a CLE and bemoan the state of settlements and the offers. And in my head, I would think kind of selfishly because I needed help at that point, and we all do. Well, when's the last time you offered to take somebody to a deposition? When's the last time you let someone sit on your Zoom and you mocked across with them? I mean, like there aren't enough older lawyers who are willing to give their time, because if everybody can try cases competently on the plaintiff side, guess what? It's better for all of us. And
you just said such an important word. You didn't say everybody's got to be F. Lee Bailey. You didn't say everybody's got to be the best lawyer ever. If the plaintiff bar was just everyone was competent in trying the case, it would turn the tide dramatically.
Yeah, and I get it. I get the market dynamics at play. I get how competitive this industry is. I do. I have 3 kids under 7 who I'd like to send to college if that's their dream, right? But it's a little bit like law school. Either you make a decision to be the guy that rips the pages out of the books, or you're the guy who's willing to share some notes to, you're not threatened by somebody else who's good, and maybe you realize you get better when you teach too. And that's where we're at. I mean, we want to develop a program in Connecticut where we help plaintiffs' lawyers get better. I mean, just even help a guy lay a business foundation to get in a police report if he needs to. There's not the same evidentiary issues show up in most car accident cases, time and time again. If you can take a law school exam on evidence on hearsay at Focus with a little bit of business record, you're in pretty good shape, man.
I once had a judge who I must have tried 10 cases in front of in Burlington County, New Jersey. And we were there for a pretrial, and he calls me up. He says, "I want you to hear this motion. I just want you to listen. Don't say a word." It was a plaintiff lawyer who was arguing that the MRI report with all its findings should come into evidence, and he doesn't have to call the radiologist or an orthopod to say what's in the report. And of course, that's going back. Of course, he can't get that in because that's
right.
That's an opinion within and he's arguing business record rule, and the defense attorney's getting so frustrated. And I finally, when it was over, I explained it to him, but the judge called me up. He said, "See, this is what we deal with." And I'm like, "Oof."
Well, right. And then or in Connecticut, thankfully we don't have that. I can be like, look, you might want to take a look at 52-174, which says that every medical record, if it's signed by a physician and that would qualify with that MRI report, that's coming in automatically. You don't have to call them.
Wow. And even if it's got an expert opinion like that,
if it's got an impression, I mean, even narrative reports, if they're in a medical record, they come in, you can depose them, you can cross-examine them if you'd like, if you want to. But I mean, but even just knowing okay, how are you going to get your records in, buddy?
Exactly. So let me ask you this, because I know we're going longer but you're such a pleasure to talk to. You're wealth of knowledge.
I could do this all day. Just talk shop.
Yeah. The sad part is that's what I do. It's exactly what I do all day. So, you're going now. It's obvious the case isn't settling. At least in your opinion, it appears to you that the main defendant is not necessarily acting in good faith.
Yeah.
That doesn't mean they're lying. I mean, they're not trying to really settle the case.
Yeah. We're too far apart, to quote the obvious.
So now you've got to make some decisions, right? You've got this case. It's a monster. You've got all these transcripts, and you're trying to whittle them down to, if you can, 5 days of trial time. And it doesn't sound like you were able to do that, but
No. No, Connecticut, I mean, even jury selection is in state court. You have a constitutional right to talk to jurors one at a time. So selection took almost 2.5 weeks.
Oh my God.
Yeah. And then the trial itself was about 2.5 weeks.
So you literally have to do a different voir dire.
Yeah. It was about 45 minutes of questioning all in across all 3 defense lawyers and me per prospective juror.
Right.
Before you even, exercise peremptories or thought about it. So,
well, good for you. In New Jersey, at one point we were allowed 3 open-ended questions, and that was it. It was all judge driven. Oh. And if you asked anything that could have anything to do with your case, the defense would say they're trying their case in voir dire, and the judge would say, "Yes, Mr. Gruber, that's what you're doing." I'm thinking, well, yeah, that's what everybody tells me they do all over the country.
Yeah, no, it's got its pros. You can't encourage crosstalk. It's hard to encourage bonding.
Right.
Jurors that don't see each other, but you can get to know them at a level that I don't think you could otherwise.
So now you've got to make these decisions. What is the process at the Connecticut trial firm? You, Ryan, and everybody who's trying this case, the whole team. How do you decide what you're going to include in the trial, what you're just going to knock out, even though you think it's great?
Yeah. So the short answer is hire good people. I did not try this case alone. I tried it with my partner, Ryan McKean, Andrew Ranks, Alexa Mahoney. I mean, 4 people on this case, day in, day out, constantly talking about strategy, and every single day was different. I mean, we settled with every defendant but Phillips the morning of opening statements. And we knew we were going to do that. We thought that was likely to happen. So the case even changes at that point. But the answer is, I mean, every single day you go in, you do the best you can to prepare and to plan and to have witnesses set up. But we'd leave court, we'd come right back to the office, and it'd be a war room. Okay. Right. This is what just happened. You take that, you take that, you take this. I mean, be willing to work. I mean, I don't take pride in necessarily compromising my health, but at the end of the case, one of the defense lawyers we settled out with said, I don't think I've ever seen so many emails at 3 a.m. In my life, let alone for 3 weeks straight. And I was like, hi, that's me. I don't sleep. Of course, I immediately got COVID after the trial because I was so immune suppressed. But so we've learned lessons about spacing it out and getting ahead of it.
One thing and people who are listening to this are going to text me and laugh. I can be a chunky guy, and the best diet I ever had when I was still practicing was trying a 2-week trial.
Yeah,
that was by far the best. 8-9 pounds. I'd be in a hotel room for 2 weeks. It was great. I'm not sure that's healthy.
Yeah.
But what do you think? And only because we're running out of time, but if it's okay with you, I would love to do another sitting with you even for the next trial and then get a little bit more into your thought process. Because your thought process is dead. I love it. I'm loving listening to you.
Well, I appreciate that. And like I said, I wouldn't be here without other people who've given of their time. And I'm happy to share what I can. And I'm happy to do the same for anybody that feels like they need someone to talk to or want somebody to talk to. If
somebody wants to get in touch with you, they can just go to the Connecticut trial firm, the webpage, and they'll be able to do it that way.
Yep. Or they can just shoot me an email. My first name, Andrew, at CT, like Connecticut, cttrialfirm.com. And that comes right to me.
Awesome. So now you get this huge verdict, and I'm actually looking at the verdict sheet you were nice enough to supply to me, where they did not think Phillips failed to train their agents. Did that scare you when you got that first answer?
Yeah, because that was the first answer. Well, so I'll tell you the very first question out of the jury. They started deliberating at like 10 a.m. and they said there's a question. That was about 11:30, and the question was they want to know more about the life care plan. Now, as a plaintiff's lawyer, you feel pretty good about that, but you're also a lunatic, and you know that until that verdict's inked, you convince yourself maybe they're just counting the exhibits and they have that one, but it feels like they're on past liability pretty quickly. So we thought to know. And then the very first specification is, did the plaintiff prove by preponderance the evidence that Phillips failed to train its agents? The answer was no. And then, of course, failed to supervise was yes, and failed to safely package the product was yes. And we said, okay, great.
Was approximate cause was yes.
Hold your breath, because they tried the case on a weird theory where they wanted to blame the employer under a sole proximate cause theory, but also apportion liability, which is probably outside the scope of the time we have left, but was crazy. And then the interesting thing happened. My ask on economics was for 15. I told them, empowered them to go higher or lower. But you see what they gave us for economics.
15. They gave you what you asked for.
No, so I think it's 50. Like, I think I got to look at the verdict form. It was more than I asked them for.
Oh, well, for the main plaintiff, it was 15.
Oh no! So you know what it was? Yeah, I apologize. I misquoted earlier. So the economic ask was actually lower. It was
Okay.
actually I think 7.5 or 8 million.
So they doubled it.
Right. So the very first line is 15 million, and then your brain starts to spin out, and you go, well, they could have gone higher because we gave them the flexibility
Right.
to award him more care if he needed more. But is that a compromise verdict? Is it like some people could see awarding damages for economic damages or not? And maybe the economic, and then the next non-economic line for my client was 75 million. And those thoughts kind of vanished.
Yeah. Did you hear after they said 75 million, honestly? Did you hear anything after? Because there's a few questions that are still have to be answered.
Yeah, it was.
Were you still able to hear it?
I was able. It was an out of body experience though, because at that point, I mean, Ryan, he'll tell you. I mean, like we had been wound so tight for so long, and all we wanted was justice for our clients. And
Sure.
I mean, we exhaled. We said, look, they saw him, they took care of him, and then we're especially proud. Alexa Mahoney from my office, who's an incredible lawyer. Congratulations to her, by the way. Her baby was born last night.
Oh, that's awesome.
Shout out to Wes Mahoney and Alexa. But she was tasked with being his Emily Lopez Cruz, our client's wife's lawyer, because we realized through focus groups they wanted her to have her own story, her own case, her own lawyer.
Absolutely.
And the $10 million verdict they gave her for her loss of consortium claim was the biggest loss of consortium verdict in Connecticut history. So there were these moments during trial where they just didn't value her. They disrespected her time, her care. And we said, look, we know you see her. We know that her life matters and that you'll value that. And we were like, so in its own right, that verdict was huge for us. I mean, we were so thrilled that they saw him, but also they saw them collectively.
Take me to the point, because this is why we do what we do. Take me to the point when you look at your client. And they both, he's in the courtroom, I assume.
Yeah, they were both there, yeah.
And they both realize what this verdict was. What is that feeling like? You're looking at them, they're looking at you. I mean,
it's the first time I think I had seen genuine relief on their faces. I mean, we had settled for 8 million with the other defendants before opening statements. So there was something there that they knew, okay, we have something. But there was a level of relief, I think, both in that it's over, that they saw us, that we don't have to worry about when he needs a new wheelchair and fight workers' comp about that, or we can get a house that doesn't, he was living in an apartment that the fence was built too close to his ramp in his backyard. He'd never been in his backyard, even where his grandson plays. He'd never been up to the second floor. He'd actually gotten rid of the stand-up walker because it didn't fit in his kitchen. It was like to be able to think I could build a life in a house that works, that makes me feel like I have my life back.
Wow.
And that was actually one of the bigger moments for us. We got to see the house that they bought, and they're still very modest. They bought a house about 5 minutes. I think they wanted to be next to us forever, which we're okay with. In the town over, like one level, renovated. I mean, just to see how much room he had and the place that they're trying to build for their grandkids to come and be. I mean, it's the single most rewarding case I've ever handled. It may ever handle, but yeah.
There's just something about, then we'll both get emotional. There's just something about the bond you have with a plaintiff that you tried a case for, win or lose, that they know you did it all. You left it out there. There's that bond. That's just, I still get cards. I live in Florida now. I don't even live in New Jersey anymore. And the cards still find me. Happy Hanukkah, Merry Christmas. It's just wonderful. I would love to have you and maybe some of your team back on next time, where we can really go through some of the nuts and bolts of how you broke it down.
That'd be great.
That'd be awesome.
Yeah, this would not have been possible without them, and
yeah,
I'd love for them to get to share, get to spread some of their brilliance around.
Well, Andrew, it's been great. Thank you for kicking off our third year. Connecticut trial firm, and they're making life easier for people in Connecticut and safer. Congratulations. It's just absolutely awesome. Thank you so much for coming on. I really appreciate it.
Thank you for having me. It's been a pleasure.
I told you it was going to be really good. Andrew, his way of thinking, his way of analyzing things, and his just relentless attitude was such a joy to talk about. And he's like most people who listen, our guests on the show, and of course me, we're all trial nerds. We're all looking for the best way to do things and the most intuitive and smartest way to do things. And Andrew and his partner Ryan McKean are just killing it and knocking it out of the park with every case. Since that last verdict, he's had another $2+ million verdict just recently. So their way works. If you have any questions and you want to find Andrew, you look at for CT trial firm, I think it is, .com, or just Google Andrew or Ryan and you'll get to them. They're great people to work with in the state of Connecticut. And again, this is Saul Gruber from Gruber Trial Consulting, your host of The Jury Thinks What, a podcast by trial lawyers for trial lawyers found in the Lawyer Minds ecosystem. And we'll see you in a few weeks. Thanks for listening. Bye.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.